You're watching Bill on Bankruptcy. I'm Lee Pacchia. I'm joined now, as always, by Bloomberg News bankruptcy columnist Bill Rochelle. Be sure to go read his daily bankruptcy column. It's available on BloombergLaw.com, and it's also on the Bloomberg Terminal. All kinds of good stuff to run through this week. Bill, welcome.
Good day.
And Bill, for our case of the week, we almost have a joint filing, as it were. We have AMF Bowling and Ahern Rentals. They're both our cases of the week. What do they have in common other than starting with the letter A?
Good point. They are both very good examples of the very frothy market we have for junk debt and distressed companies. It seems as though for some investors, no company is too troubled so that you pass up a buying opportunity. AMF, of course, is the bowling center operator. There, the company is going to emerge from Chapter 11 thanks to a $260 million loan. And on top of that, the second lien lenders, who will take ownership in exchange for their debt, are going to make a $50 million loan. One of the folks in the case told me that it looks like AMF, coming out of Chapter 11, is going to have about as much debt as it had going in. The second case is Ahern Rental out in Nevada and surrounding states, I guess we should say. It is a very, very large equipment rental company. They are going to emerge from Chapter 11, owned by the same Mr. Ahern. He has put together a $350 million loan package, and if that were not enough, he has just surfaced a second loan package for $415 million, which pays off the senior and the junior secured creditors in the case. This, I think, is another example of how people with money burning a hole in their pocket are very willing to make loans no matter what the risk. Because if housing runs into trouble again or commercial construction, I would tend to think that Ahern Rental is going to have problems a second time around.
Right. Chasing yield by playing in the junk pile. It's
That's right.
Gotta love quantitative easing.
Well, listen to this. Listen to this. Moody's Investor Service told me something in a report today, which I guess I could have guessed at but didn't know. They said that in the first quarter of 2013, there were $80 billion of covenant-lite junk bonds that were sold. Now, get this, Lee. That's more covenant-lite bonds than all of 2012.
Really, really interesting. We have a couple new filings to report this week. It's been a dearth in this bucket for us for a long time, but we have three coming on the same day. Tell us about them.
Well, they're all fairly distressed companies, which I guess is normal, seeing as how they're in bankruptcy. The first is called DB Hess. That's not Hess, the oil company. This is DB Hess, the commercial printer. They're out in Ohio, but of course they didn't file in Ohio. They filed in Delaware. They are selling this substantial company for $19.3 million. And as a result, holders of about $74 million in second lien debt are going to recover a gigantic 2%. Pretty sick company. The next is called Highway Technologies. This is a company that makes or sells or distributes barriers and guardrails and signs and things like that for highways. They couldn't even find a buyer. They tossed themselves into bankruptcy, and they're basically going to sell the business, the 30-odd locations, under the hammer. The third is a very worthy not-for-profit called Kids Peace. They run an acute care psychiatric hospital for children and have a whole bunch of behavioral outpatient operations for hundreds, if not thousands of kids. They put themselves in Chapter 11 to reduce bond debt from $51 million to about $24 million. But on top of that, they have $100 million underfunding on a pension plan, which they have to deal with. And I certainly hope they can pull this off. It'll be like pulling a rabbit out of a hat.
Not tiny companies here.
None of them. None of them at all.
Really interesting. And we have a Judge of the Week. This time it's Judith Fitzgerald from Pittsburgh, Pennsylvania. What did she do?
She wrote an opinion about 150 pages long in a very complex asbestos case called Specialty Products and its affiliate Bondage. those companies are subsidiaries of RPM International, which is the maker of Rust-Oleum. The Rust-Oleum people had a very novel theory at this trial that was held in Fitzgerald's court to decide what the universe is of asbestos claims for these two companies, Specialty Products and Bondex. The owners said that most of their claims are nuisance claims, where they have been settling in the past, even though in reality they say there is absolutely no liability. It was cheaper to settle than not. So they wanted Fitzgerald to ignore maybe half of their potential liability for these so-called nuisance claims. Fitzgerald said, no way, Jose. It doesn't make any sense to me, because if you and the other side were willing to settle beforehand, that claim is not worth nothing. I really very much appreciate what Judge Fitzgerald does. In this particular case, she found that the universe of liability is almost $1.2 billion, but more than that, she is the judge who has been assigned the horrible responsibility of presiding over practically all of the asbestos cases in the Third Circuit. And believe me, that is like pulling the short stick when you're in a contest. It is a thankless job, but she performs yeoman service in this and in other cases.
Right on. Kudos to Judge Fitzgerald. And finally, we have some advance sheets to go to. This time, it's a really important opinion out of the Third Circuit Court of Appeals in Philadelphia. What's it all about, Bill?
Well, tell you what, I'm going to ask you the question, Lee. What are two of the most complex areas of federal law?
That's a tough one. That's a subjective analysis, but I'm going to have to say bankruptcy, because it's so complicated that it needs a weekly web TV show to walk the general public through the issues, just to toot our own horn there. And I'm going to take a gander. Again, this is subjective, but I'm going to say tax. Is tax there?
Bang.
Nice.
You had
nice.
It. You win the door prize.
Right on.
This case from the Third Circuit is right smack dab at the intersection of bankruptcy and tax law. When I read this decision written by Circuit Judge Kent Jordan, I got a headache. I don't know when I have read such a complex decision. Here's what it's all about. It made some very important law for bankruptcy and perhaps also tax lawyers. The question is, if you are a subchapter S corporation, is your tax status an asset of your bankrupt estate? Now, by the way, for those of you who don't know, a subchapter S corporation is one where, although it is a corporation, it itself pays no taxes. All of the tax liability or all of the losses flow upstairs to the individual owners. There was a company called Majestic Casinos in Chapter 11 in Delaware, which was a subchapter S corporation. The owner, midway in the case, terminated subchapter S status. This had some unfortunate tax consequences for the creditors. So they ran off to bankruptcy court and said, no, you can't do this. This is an unauthorized interference with estate property. Namely, our subchapter S status is a piece of property that the bankruptcy automatic stay protects. The bankruptcy judge bought the theory. It was rejected on a direct appeal to the Third Circuit by Circuit Judge Jordan. He said, no, in fact, your tax status is not an asset of the estate. He had to distinguish a number of cases, particularly those, even from the U.S. Supreme Court, which hold that tax loss carryforwards and tax loss carrybacks are, in fact, property of a Chapter 11 or bankrupt estate. But he had pages and pages in this 55-page opinion explaining why that does not carry over to subchapter S status. Now, I have to say there is one non-tax statement in this opinion that is very important, and I suspect will be trotted out by bankruptcy lawyers all of the time. What Judge Jordan said was, simply because you have some package of rights which are valuable to the bankrupt company, that does not automatically mean that those rights amount to property in the bankruptcy sense, which is protected by the automatic stay, and nobody can muck with it except with permission of the bankruptcy court. So although this gruesomely difficult opinion is hard to understand on many levels. On that level, it's pretty easy to understand, and I think it is for that reason a very important decision. The case might, or the issue might one of these days, go to the U.S. Supreme Court, but I don't think it will as yet because no other circuit court has reached this issue. Maybe if we live long enough, there will be a split of circuits, and then we will find the issue go to the Supreme Court.
Really interesting. Bill, thanks for that. That's Bloomberg News bankruptcy columnist Bill Rochelle. If you'd like to learn more about the cases and issues we just ran through, be sure to go check out Bill's column. It's available on BloombergLaw.com, and it's also on the Bloomberg Terminal. I'm Lee Pacchia. Thanks for watching. See you next week.